Hi everyone, I am Talisa Taylor, your host for today. Recently, we hosted part one of 3 real estate webinars. Our first webinar spoke to your best financial decision for real estate, exploring your options. Today, we will address large-scale real estate developments, important considerations. Through this webinar, we will focus on stages of large-scale development, understanding zoning laws, financing or funding large-scale developments, and legal matters or notices to consider. Our first speaker is Shani Lovindeer, who serves as a Senior Project Manager, Joint Venture Unit at the National Housing Trust for over 10 years. She's a corporate member of the Jamaica Institute of Engineers and a member of Project Management Institute and local Dr. Bird chapter. She is presently the head of operation at Proven Rents Limited. She has spent over 21 years cultivating extensive knowledge and experience in the real estate investment and development sector, of which over 13 years was at an executive management level. She will speak on stages of large-scale development and financing or funding large-scale development. Shani, welcome.
Thank you, Talisa. Thank you for this opportunity to again be part of a discussion about real estate. And I would also want to acknowledge Gavin, a fellow panelist. Thank you, Gavin. And welcome and good day to our listeners and viewers here and abroad to this, the Gleaner Premium webinar, the second in the series for 2022. I have a presentation that I'm going to bring up. All right, so Talisa, thank you again for the introduction. And I will head straight into our conversation about large-scale real estate development, in particular the stages. Let me just set the stage for the discussion. Talisa already outlined my career highlights. I want to point out that I'm happy to be a part of the Proven REIT team. We have, collectively over, I would say, 150 years of experience in the real estate investment and development industry, particularly with respect to developing large-scale real estate portfolio in both residential and the commercial space. My background, as Talisa outlined, I'm a certified project management professional, and I'm also a registered professional civil engineer in Jamaica. So I will be talking about the stages of large-scale development and financing and funding of these types of projects. Now, I want to keep the discussion simple, but the process is by no means easy, just so that we can have everyone involved and have full participation. So it's not going to be, technical, and I'm, avoiding some of the high-level technical jargon so that we can all understand. So let me set the stage. There are some key terms in the topic today, and I want to just have it, ensure that everyone is with us and we're all together. So real estate, essentially and simply put, it's land or temporary or permanent structures on land, or a combination of both. And what we mean by development, it's the building of any structure, whether new or we're renovating or modifying existing structures for particular uses. And the objective is primarily to increase value, or what we're probably most familiar with, is building with a view to selling for profit. And the distinction that we're making here is we're talking about large scale real estate developments. And aside from the obvious, fact that we're talking about perhaps size, we're also talking about complexity. And for complexity, for the purpose of this discussion, what I would like to set the stage on is that it's a project that typically involves a team of technical experts it requires planning approval and building approval. And there are many agencies involved in that process. From the Jamaica standpoint, I would argue that we're talking about, for example, projects where land is subdivided into 10 or more parcels and commercial and industrial facilities. Other territories may have different planning requirements and different levels at which, or threshold at which, planning and building permits are required. What this presentation will be about, the stages of development. The main stages, and you'd be aware perhaps that there are many versions of this, but I have essentially categorized them in 3 main areas, which is planning, design and approvals, construction, and post-construction. So I'll go through those 3 stages and pull out some of the main aspects of the stages that is involved in the process of large-scale real estate development projects. Now, I want to add here that the large-scale real estate development projects impact the society at large as well as the individual level. So persons who may be interested in real estate development, large-scale development, offers opportunities for employment, career development, and obviously wealth creation as well. So this presentation is for investors, developers, the public at large as well, and persons who are just genuinely interested in the process and perhaps why it may take long, i.e. more than 12 months, sometimes 3 years, 5 years. So in the planning stage, one of the key areas to look at, or that it's considered by developers, is the location and what the property is permitted to be used for or developed for. Part of the planning process involves market research. Developers need to either have the skill or have a team member on board who possesses those skills to be able to obtain market data, analyze the data, and do forecasting with a view to identifying investment risks and potential competitors. A lot can happen during the course of undertaking a project. Projects typically take up to 2 or more years. The market conditions may shift, demand may change, global events may impact either positively or negatively on a project. Competitors may come on board and detract or create opportunities or perhaps situations where selling or disposing of the property could be difficult. The location of the property is also important depending on what your desired use is, whether it be for residential, commercial, or industrial, which are the typical broad headings of real estate development classifications. We're looking at whether the property in question is in a highly desired area. Is it accessible? What are the site conditions or features that will add to the building costs? And also, which is important, is the permitted use. I know Gavin perhaps will touch more on that. I will focus on just the technical parts of it, which is the implementation of the projects. But it's important to know what the property and the area where the property is zoned for. Where you can get that information is from the planning agencies. In the case of Jamaica, that would be the National Environment and Planning Agency, and also information information is on the actual title of the property that will describe the restricted use, and developers should be mindful of that if they are doing a new acquisition or if they're seeking to modify or change the use of the property. Changes in the use of the property may involve a lengthy approval and legal process, and may also involve community consultations, which may be required by the planning agencies. The second stage is the design and approval stage. And here, there's a lot more technical work at play. The project usually has a team of experts that include architects and engineers who are tasked with going about designing. Now, a successful design is predicated on being clear about the target market. It's important to identify the right target market for the project so that you can set the appropriate goals for the project, such as what's the targeted selling price, or if you're holding for rental revenue, the targeted rental rates. So that's where, if you recall in the planning stage, your research would now help you to work closer towards your end goal. And once you stay as a developer focused on the end goal, it's easier to make decisions and not get distracted by perhaps sometimes the temptation is to overbuild, over-design, and the belief maybe that you can make it back on the back end, but that may not be supported by the target market. So if a developer stays on track, stays focused, decisions can be made even at the stage where the information is limited at this point because the designs are not yet completed. Also important at this stage is, with the target market in mind, is to also have a marketing plan. The marketing plan will help you to know how to communicate with the target market, and this will help you to minimize additional costs that may arise if you start to market to the target market too late, and that could give rise to holding costs, which is essentially the cost you bear because due to delays or lengthy times to complete and close sales or find the right tenant. Now, what makes a design, effective, efficient? What makes it attractive? So an efficient design, it makes best use of the property. It optimizes the potential return on investment whilst being compliant with local planning regulations and building codes. I also suggest, and there are growing trends and movements, very active movements towards factoring in environmental issues with a view to renewability and sustainability. So developers are mindful, and investors, whether the product is in line with industry trends, consumer preferences. And if that occurs, then it is likely you will have an attractive product that is in high demand. And of course, it means that you should be able to close sales fairly quickly and obviously optimize or maximize your revenue or profit, depending on the strategy. Now, this is where we talk about the difference between, say, a large scale and, small scale or simple projects, basic projects, where implementation requires a lot of planning. It would be detrimental of any developer to go into a project of this scale without having a clear plan. This plan will help to minimize or avoid costly and time-consuming mistakes caused by not taking account or factoring in important aspects of the project, such as the cost, the features of the product that is being built, as well as the order of things. And now more than ever, and that also includes consultations with stakeholders and approving agencies to ensure compliance, and that the community at large is aware of the planned development project. Buying at all stakeholder levels, both local as well as the larger community, is important for a successful project. Such a plan should include a detailed budget, a detailed schedule, the proposed or planned construction methodology, and also importantly, a risk plan. The last main stage is the construction and post-construction. Now, some developers typically have, they undertake the construction in-house, but if not, the developer's team will comprise of, for example, the financial advisor, design consultants, the analyst, the project manager, contractors and suppliers, real estate agents in the case of if you're selling for profit, or property managers if the property is being held as an investment or for rental income. A lot of persons, often think, that real estate development is primarily about the construction because that is what you see on ground. But there's a lot of design work, planning work that occurs before you see the construction. But notwithstanding, the construction process is also very involved because it involves human and other capital. And the coordination of this capital, of these resources, is critical to preserve life, protect property, and to ensure that you have and can assure good quality and compliance with building codes and environmental standards. So all of these team members work together in a coordinated and collaborative approach to maintain the integrity of the product and to deliver efficiently and on time. And the objective primarily and generally speaking is to deliver on time and within budget. Now, the other aspect of the product, which is also important, which I'll touch on here, is budgeting and financing. This aspect should actually occur at the planning stage because one needs to have that in mind before the developer goes too far down the road and then discovers that he's not able to complete the project. The project budget, the components of the project budget should include the big ticket item, which is typically the construction cost, but it should also include the property acquisition cost. That's the cost to acquire or purchase the property. It also should include the cost to engage the professional team, sales and legal fees required to transfer the property and to complete sales. The cost to obtain approvals. Oftentimes there are approval fees that must be paid when applying to agencies for approval, and also the provision for other expenses which will be borne out through the risk plan. Underestimating or leaving out major expenses could be detrimental for a developer, so the developer, I'm highly recommending that the developer ensures that he has a team member who has the skills to put together the budget and try and not to cut corners in the preparation of this document. The other documents that work in tandem with the project budget is the cash flow projections. So this is where the financing comes into play. The cash flow projections indicate or outline the timing or when the expenses for the project will occur throughout the phases of the project. A financial manager with experience in large-scale real estate development projects can help to prepare these projections as well as assist with sourcing the funds for the project. And I emphasize that the financial manager should have experience in large-scale real estate developments because they would know or be aware of the many components involved compared to, say, a small-scale real estate development project, which may not have as many components. So large-scale real estate development projects typically require purchasing of building materials that include paint, cement, sand, gravel, tiles, and all of that needs to be planned ahead of time to minimize delays. The right financial structure or the right financing structure for a project should boost potential rates of return for investors and should be aligned with the risk profile of the project. And what I mean by that is the structure of the loan, as if you're seeking debt financing, should match the type of project, the scale of project, and the duration of the project. It's not advisable, for example, to have a product that's being built for sale and you have a loan that's actually not matching the timing of the expenses, the requirements for repayment are not aligned, for example, with anticipated sales proceeds to allow for the developer to actually repay the loan. Investment projects loans should match the holding period, ideally, of the property. So for example, typically developers have a holding period of 5 or 7 or 10 years. A successful developer should shop around for loan products that are aligned with the revenue streams of such an investment property. So it's not just looking at the amount you're going to borrow, which is typically what we do at, say, the residential or retail side of things. And the popular products offer, say, 90% financing, 95% financing. Commercial loans typically have a financing level of anywhere between 50% to 80% for seasoned developers with a track record, because of the risk in that space as perceived by lending institutions. There are also atypical terms which differ from, say, residential mortgages that include the repayment structure. Some loans offer have a facility where you're paying interest only, or you may choose to have principal and interest payments. So interest only, the developer or owner is only paying on the interest, and the principal remains in the hands of remains a liability on the books of the developer. The developer should also look at the repayment schedule. So again, typically mortgages, you pay every month. Commercial loans, you can arrange for quarterly payments, semi-annual payments, again, depending on the relationship that the developer has maintained, sustained, or created with the financing institution. The other aspects that you should look out for are the upfront bank charges and penalties for early repayment. And there may be other non-financial conditions for compliance, such as reporting requirements and documentation submission requirements on the part of the developer to the financial institutions. So for example, a developer may be required, developer owner may be required to maintain and show evidence of insurance on the property to secure both the interest of the lender as well as the owner. So the key takeaways: large scale real estate development projects. They're complex, they're risky, and they actually may result in human, financial, and reputational loss if not done correctly. So developers have a lot of responsibility. They should know where their strengths, their weaknesses, they should know where and how to find the right team. They should be patient, they should be diligent, and they should be responsible. Complex projects require a lot of planning, coordination, and collaboration. Funding should be considered at the beginning of the project to ensure success. Developers, as I said before, need a team of experts to effectively execute the project. And the goal and the philosophy should be to be in compliance with local laws, planning regulations, and building codes. The right team of experts should adhere to established codes of professional conduct and ethics and have a good track record. So from the perspective of investors, oftentimes when the developer is promoting or is ready to sell, we look at the product. I recommend very strongly that we also look at the team that the developer has used to undertake the project. Ask questions of the developer and in terms of their track record. Have they done projects of this scale before? If you're not able to view and inspect for yourself, have a trusted partner, do those checks on your behalf to ensure that what you're buying in, whether you're buying in at the early stage as an investor in actual undertaking the project, or you're a purchaser at the back end, you're satisfied and have a certain degree of confidence in the investment that you're making. Of course, there are checks and balances that are regulated. Developers need to be licensed and registered, approved. They need to demonstrate that the approvals are in place and that registered professionals have signed off and certified on the quality of the product. So thanks again for this opportunity to participate in this conversation. If there are any, I look forward to any questions.
All right, so I learned that persons define the different stages in different or many ways. But for you,
Correct.
You have presented us with 3 steps, right? And
Correct.
your 3 steps include planning, design and approvals, construction, and post-construction. And I'm not surprised here that planning is the first step, because I can understand and appreciate that this is no joke. This is something very risky. And on that note, I noted that funding is essential and must be considered at the start of these projects. That is just a part of the whole planning process, that you must have some form of funding in mind. For the first step with planning, I've learned that we must consider market research, location, and permitted use. Did I get that right? I'm going well so far?
You got it.
And then we talk about design and approval. And I learned that it is important to select the target audience, to have a good design, and to have an implementation plan. And I was very much, it sparks my interest that you mentioned an implementation plan, because you noted that the reason for it is simply to minimize mistakes such as costs, any costs that may arise, features of products, the order of things, consultations to ensure compliance, ensuring that the community is aware. You also noted that in this implementation plan, that there must be a detailed budget, which is essential, and that risk planning is key. And I found that very interesting. And then, of course, you spoke about construction and post-construction. And in budgeting, you also mentioned that it is important for you to have someone who is more experienced to assist when it comes to budgeting, because you will have costs such as property acquisition costs, cost to engage professional team. There's also the sales and legal team costs, costs to obtain certain approvals, and provisions for other expenses noted in the risk plans. So you see, I take in all of that, I absolutely loved it. And I really learned a lot. And I want to open the floor to questions. All right, let me ask my first question from a Gleaner Premium subscriber. The question is there a prescribed process for strata developments or other considerations that may be different from the stages mentioned earlier?
Okay, great. So the question, I'll summarize or paraphrase. Is there anything different in the process when it's a strata? So I'll try and describe what a strata is. So a strata is typically when you're building products where some of the products are technically in space, meaning that there are apartments, for example, on the ground, but there's another unit above it. So it's not connected to land. So the process is the same, except for an additional couple of steps. And the main one is that you require the submission of what is called a strata plan. Now that is prepared by a land surveyor and submitted, wherein the products that are essentially above ground, not connected directly to the ground, is lodged. And they have their own, their technical issues with that. I'm definitely not a commissioned land surveyor, but it's just to be aware of that main additional step and to plug that into the schedule as well as your budget. In other words, essentially all bits of information feeds into or affects at least two aspects of any project. It's either the schedule, the budget, or both.
Okay, my other question is from another Gleaner Premium subscriber who asked, what are some of the approvals needed or that must be considered for large-scale real estate development?
In Jamaica, for example, there are many agencies involved. And for example, in the Kingston and St. Andrew area, it primarily involves the Kingston and St. Andrew Municipal Corporation and the National Environment Planning Agency. Those agencies actually circulate the applications to other agencies, for example, the National Works Agency that primarily looks at drainage and access issues. For example, the entry and exit points in relation to major highways or major transportation routes. In other areas of the island, it may actually involve the Water Resources Authority, where there is actual potential for intrusion or pollution of underground reserves. In the bauxite area, it may involve consultation with the Jamaica Bauxite Institute as well. So it's important to have a consultant, whether you call them a project manager or a development manager, who is aware or at least knows to ask the question and knows where to ask the question about the approval process. Because if you miss an agency, you could be adding months to your project in terms of in the approval stage. If you don't take into account some of those other agencies' requirements, you could be talking about back to the drawing board and redesign. Other critical agencies for, especially for high rise, is the Civil Aviation Authority. There are others as well. You have the Environmental Health Unit if you are actually building a sewage treatment system or sewage disposal system on the property and not connecting directly into an existing system. For example, one provided by the National Water Commission. So it is involved. I can't go through it here. I'm just saying it's more than 5 agencies.
Wow. So this comes down to a lot of planning.
Yes.
All right, I have one last question for you before we head on over to Mr. Goffe. The question from another Gleaner Premium subscriber is, financing is a critical element. Is it a no for developers who want to start marketing based on a model unit in order to finance the project?
So is it a no if developers want to use a model unit to start financing the project? Wow. Yes. A model unit, you are way down the wicket. You have started construction, so I guess you've used your own funds, and you run the risk of not being able to find the balance of the funds, whatever that may be. You're putting yourself in a lot of pressure. You're perhaps not, at a strong point at this point, because you could be chasing, depending on the financing that you're seeking. If it is a nominal amount, say, I don't know, 20% that you need to find to complete, perhaps you can do it, but it's not recommended, because the other factor is that, as I said before, most bits of information affect at least 2 aspects of the project, the schedule or the budget. The sooner you can factor in or make provisions for what is called financing charges in your budget, the better you are at presenting to potential purchasers what the selling price is, and to have some level of comfort if you're looking at selling. If you're looking at renting, maybe not so much, but you can still factor into it. I'm not aware of it being a common practice, but it's possible, but I don't recommend it. Another agency, for example, that you need before you can start marketing is the real estate board, before you can start publicly marketing to purchasers. And they have their own requirements as well, which may include providing evidence of your ability to complete. They also have restrictions on how the funds from deposits are used. Oftentimes they ask that the deposits are put in an escrow account, and that is primarily to protect investors from risky activities pursued by developers, which may cause projects to come to a standstill due to lack of sufficient financing.
Wow. Thank you so much, Shani. That was definitely a very good presentation. I absolutely loved it, and I learned a lot.
Thank you.
Our next speaker is Gavin Goffe. He is the head of litigation department at Myers, Fletcher and Gordon. He's a member of the Council of the Jamaican Bar Association and sits on its employment law committee. He is a member of and former chairman of the advisory board of the Salvation Army, Eastern Jamaica Division. He's also the honorary counsel to the British High Commissioner in Jamaica. The labor practice group that he leads has been involved in several landmark court decisions related to unjustifiable dismissals in Jamaica. He has also been involved in groundbreaking cases concerning planning and development regulations. Gavin, welcome.
Hi, good afternoon, Talisa. Hi again, Shani, and good afternoon to the listeners and participants and attendees in the webinar. It's my pleasure to be with you here this afternoon, and I hope I can follow on competently from what was a very informative and clear presentation given by Shani on this interesting area. I don't have a PowerPoint presentation, so you're going to have to look at my face for the next 15 to 20 minutes. So I hope you don't mind. We're talking about zoning laws and regulations. A lot has been said in the public domain and in the press recently about conflicts where zoning laws and regulations come in. So it's timely that we're having a webinar about it so people can kind of understand why all of a sudden we're having these kind of issues and what the direction they should take should be in light of some of the challenges that other developers as well as purchasers have faced recently where large-scale real estate developments are concerned. I want to touch briefly on something which hasn't been mentioned thus far, and it's not really in relation to zoning laws, but it's important to make this distinction that both zoning laws and what we call restrictive covenants are important aspects of what a developer has to deal with, certainly from the earlier stages, from the planning stage, as Shani would have mentioned. Now, a restrictive covenant isn't something that is part of our law. What a restrictive covenant is, it's essentially a contract, a contractual provision made between landowners that essentially runs with the land and is passed down from one owner to their the person who takes on that land after them. So you can have restrictive covenants which have been in place for 50 years, from when Kingston or St. Andrew or anywhere in Jamaica look very different than how it looks now. So one of the things that you will see very often in some of the restrictive covenants is that it might, for instance, prevent or prohibit the owner from subdividing the land. And that may mean subdividing, it may mean either subdividing a larger parcel into two smaller plots of land, or it could even mean subdividing it in connection with putting up an apartment building or townhouses. So if there is a restriction on the title, and there is maybe good reason for that, having that restriction, it may well be that people are uncomfortable with having an apartment building go up next to them. And there are reasons for that, including the strain on resources and privacy issues. And so if you have a restrictive covenant on your title, and your neighbor does as well, which says that we are not going to subdivide our land, whether to make the plot smaller or to put up a high-rise apartment building, let's say, then that will be something that you should be dealing with and addressing at the early stages of your development, as opposed to once the building has already gone up. And that's part of the reason that we've had some of these issues recently. It's because sometimes it takes a little while. You do have to go to court sometimes to get these restrictive covenants modified. And sometimes our eager developers believe that it's bound to happen. They're bound to get it. And so in order to kind of expedite the entire process, they start building before they actually have the covenants modified. And then find themselves in sometimes a long drawn out court battle with the neighbors over this breach now of the restrictive covenant. And so that's one area in which you need to certainly be very, very careful. And when you have an attorney on your team who is assisting you in the development, that's one thing that they're definitely going to be advising you of in very early stages, that there is some legal work which may need to be done to modify or discharge these restrictive covenants, and that should be done from the outset before you actually start preparing the land for development. So apart from the restrictive covenants, which may be on the title and which are part of a contractual arrangement, you also have laws, development laws and planning laws and regulations, which are supposed to be a guide for the developer and their team as to what's permissible on that particular land. So the development laws will speak to a number of different things, and the regulations. It will speak to, for instance, things like the permitted use of the land. As Shani was saying, there are some parcels of land which could only be used for commercial purposes, but not residential, or only residential purposes, but not commercial. And there are others which may have a mixed use. And so if you're purchasing a piece of land which is zoned for residential and you want to go and put up a commercial building there, you would first need to apply for a change of use to the relevant authorities, or else they would not allow you to put up a commercial building in a residential area. You also have things like density, which is a big issue. And a lot of the reasons why you see some of the conflicts coming out now is because since about 2017, thereabouts, there's been a move by the regulators to increase densities. And that's what's accounting for many of the high-rise apartment buildings that you're seeing around Kingston and St. Andrew. That increase in density is what leads developers now to try and capitalize and be able to put up apartments, which have proven to be very lucrative in the last 5 or 6 years. Now, density essentially refers to how many people are expected to be living in a particular space. How many people are expected to be living in a particular space? But it is not represented in terms of people, it's represented in terms of what they call habitable rooms. Now, a habitable room is essentially an area in your house which somebody could live in, as the name suggests. So a studio, which is less than 500 square feet, would be considered one habitable room. But a one-bedroom unit, which has a bedroom and a living room separate, might be considered 2 habitable rooms. So when you're looking at density, it's really expressed as a function of how many habitable rooms are going to be permitted within a particular geographic area. And it changes. There's an actual map which displays the number of habitable rooms per acre for different areas of Kingston and St. Andrew, for argument's sake. So what has been happening recently is that some areas which before 2017 had been zoned as being 30 habitable rooms per acre might have been increased to 50 or even 75 habitable rooms per acre, meaning that the authorities are prepared to allow you to put up more units or sometimes larger units on a plot of land, whereas before it could only be, for instance, a single family residence there. So the density restrictions are there, but one of the challenges we have with the density restrictions and with many of the other zoning regulations is that they really haven't yet been properly passed into law. They're kind of in still a very a provisional state, and they're still being reviewed. But as with so many things in our laws, when we take a long time to concretize something, if you pardon the pun, if you take a long time to actually put this thing and set it in stone, then there becomes a lot of misunderstanding, misinterpretation, or even conflict surrounding whether this is applicable and to what extent can I safely rely on something like this to invest, sometimes hundreds of millions of dollars in. What will happen if it changes and in the middle of my development, and what rights would neighbors and surrounding members in the community have to rely on these provisional regulations, which have not yet been finalized. So it is unfortunate that we've been now going 5 years, coming up to 5 years since these provisional development orders for Kingston and St. Andrew and the Pedro Keys were published, and they still haven't been confirmed. But in many respects, developers and the regulators are treating these provisional regulations as if they are the legal and binding regulations. And that then creates not more confusion, because it doesn't seem as if they're treating all of those regulations in the same way. So for instance, density, as I referred to earlier, they're treating that as if it's already in law, but some of the other provisions, not so much. So it does leave a certain level of uncertainty and does create a degree of risk for developers and potential developers. And all the more it's important that you get sound advice from your team, which should include an attorney, to help you navigate these issues. Another thing which is referred to in the development orders would be things like the height, maximum permissible height for a building. So for instance, in a certain area, you might only be allowed to go 4 stories high. In another area, 2 stories is the maximum. Setbacks is another aspect of it. A setback basically tells you how close that building can be to your boundary, or the common boundary with your neighbor. And part of the reason for the setback, of course, is privacy. You won't want to have somebody building right up against the boundary wall and looking over into the neighbor's backyard, into their bathroom windows and bedroom windows. So we want to give everybody sufficient privacy and make sure that if we have a boundary line, on either side of the boundary line, we have a certain space where the building can't take place. And that setback sometimes corresponds with the height of the building. So the higher your building goes up to a certain degree, the more the building has to be set back, because then as you go higher, it gives you line of sight into your neighbor's property as well. So we have setbacks which are in the regulations. And I already mentioned height. It also speaks to things like green space, it speaks to how much of the area needs to be green so that we don't end up having concrete jungles. It speaks to things like sewage and how the sewage is to be treated, whether it's going to be a reed bed, for instance, on the property, or it's going to be put into the NWC's sewer system. It speaks to things like number of parking spaces, the minimum number of parking spaces that you can have. So it really does go into very granular detail about what is permitted within particular areas. And it's not the same from one area to the next. So you will have a local area plan for instance, a Barbican area, different from Red Hills, different from, Stony Hill. And all of it will look at the nature of the environment and the plans that our regulators have for the area. So some areas, they want to turn it more into a tourism product. Others, it has more of a historic significance. So they want to make sure that you're not, for instance, going into Port Royal and demolishing the Giddy House or anything else like that, which has some heritage and significance. So it really is, it lays out a kind of a master plan that, the city planners have for the area that they're looking at. Now, another part of it, which is very important and which not a lot of people pay attention to, is, for instance, minimum lot sizes. And that's been something which has caused quite a lot of litigation in court. A minimum lot size. Now, for many areas within Kingston and St. Andrew, if you don't have a lot size of at least half an acre, you're not able to put up, you should not be able to put up a multi-family development. What's a multi-family development? Like an apartment building So no, part of the challenge has been that the regulators have been given a blight, so to speak. You don't quite have to have 0.5 acres to be able to get your permit, but it's not entirely clear exactly what the lower level is. So somebody might go there with 0.3 of an acre and they might not get through, and somebody else might go with 0.31 and they might get through. So again, the lack of certainty creates a degree of risk in how these things go. But as a general rule, you should be only developing on properties which are at least half an acre in certain areas. For other areas, the minimum lot size is as high as 1 acre. And if you have less than an acre, you really should be looking to put up houses, as in standalone single family houses, as opposed to apartment buildings or even townhouses. And again, your team can help to guide and advise you. Apart from that, if you have at least 10 units which you're building, then apart from the planning permission, you're also going to require an environmental permit. Environmental permit is issued by the NRCA, Natural Resources Conservation Authority, and they will look at things like density as well, but also will look at the treatment of sewage, the green spaces, whether you're going to be knocking down any trees, which are of some significance from an environmental perspective and which you shouldn't be knocking down. They're going to be looking at things, for instance, like the degree of incline on the land. And so if you're past a particular incline, or if you're in a particular area, you might need to also get permits from mines and geology to make sure that they have done the soil sampling and they make, so that you can be satisfied that when rainfall, we're not seeing people's houses being swept away into the gully, as we have seen, unfortunately, too often in our past. So there's a whole process which is involved. You have to fill out an application and send it to the various agencies, and they will consult with each other and send it around and make sure, for instance, that fire brigade don't have any issue. As Shani had said, National Works Agency might not have any issue. They're going to want to make sure, for instance, that after you finish your construction, in the post-construction phase, that you put the road back into the condition you found it. A lot of developers aren't really doing that, or don't seem to be doing that. And then if once they've gotten the once the permits have been considered, they will normally be issued with certain conditions to it. And those conditions can include things like, for instance, don't work before 7 o'clock in the morning, and don't work after 5 o'clock in the evening, because you don't want to be disturbing your neighbors unnecessarily. Might also say you can't work on a Sunday or on a public holiday unless you get specific permission to do that. Might see to things about like the noise level which you're allowed to have during the construction phase, and it will set it out in terms of decibels. And if you're going above this decibel level, then you might have to take some other kind of measures to dampen the sound. Dust control is also a big issue. So some buildings you see, especially the high rises in New Kingston, you might have noticed, they have like this blue mesh that's encircling it, and that's to kind of prevent the dust from digging out everybody else's lungs who has to live or work in the area. So all these conditions are important, but some of them seem to be more important than others. So some developers try to get away with a little some work here and there, and some developers will, exceed the noise limit for a period of time. And some of those things are inconvenient, but it's only for a temporary time and it won't cause you a problem. But other things are definitely much more serious and could jeopardize the permits which you have been granted. And for the people who are now purchasers or potential purchasers, the rules are changing. We have had some instances where developments have received their permits and have been constructed, but those permits are subsequently challenged and successfully challenged, resulting in there being a threat to the building being demolished after you've put down money on it. And that's something which is a real concern, not only for purchasers, but for the financial institutions that might be giving loans and mortgages on the security of those properties. So it's something which is a real concern, what's happening now. And it means that even when you're purchasing property and you go to a real estate lawyer to assist you with the purchase, the rules are changing in terms of the kinds of due diligence that purchasers now have to be conducting, because it's not good enough that somebody can give you a title if this land has been illegally approved. And unfortunately, there are indications that some permits are not being considered properly and thoroughly, and that there may be some other considerations which are being brought into play, whether it's political or financial considerations, which are affecting the grants of these permits. And so that creates an unsafe system for everybody, because all it takes is for one high-rise building, which has, $250 million worth of security pledged on it. Only takes for one of those things to come down, and now, people are in financial difficulties, including things like pension funds, which may have invested in some of these units. So it's a very serious issue, and the recent developments are being considered by our courts as well as by the regulators themselves to make sure that we strike the right balance, because everybody wants our city to be developed, and everybody wants us to improve the quantity and quality of the housing solutions certainly in Kingston and St. Andrew and further afield. But I think we all understand and appreciate that it needs to be done in an orderly fashion. We need to make sure that we are all playing by the same rules, and that you don't have friend and company business going on and people getting permits because of their connections as opposed to on the merits. We also want to make sure that these buildings are safe and that it accords with the vision that we have for this city, or that those that we elect have put in place for the cities and spaces that we live in. Because if we don't get it right, nobody wants to be living in an ugly town. Nobody wants to be living in a concrete jungle. Not many of us do, at least. And at the same time, these policies help to regulate the cost of housing solutions. So, for instance, if you have minimum lot sizes, it means that the market pressure on people who are, I should say, the market will be removed, for instance, from owners who have small lots and are now looking to sell them for much more than they're worth, because you really shouldn't be able to do that. So to give you a real life example, there are a lot of usually older single family home residents, people in the late 60s and 70s who've been living on a piece of land which is less than half acre for a very long time. And the value of those lands might have, before 2017 been viewed as, let's say $30 million. But with the influx of developers now looking to buy up these lots to be able to put up an apartment building, these prices are now doubling. And so people who want to buy single family homes are having a challenge in finding it, because they're competing with developers to try and buy these homes right now, to buy these lots, I should say. The developer, of course, wants to hit it down and build up apartment building, whereas maybe a young professional is looking to raise the family and have a little green space where the kids can play. And so it's really important that we get this balance right, and it's really important that we understand why these rules are in place, we respect the rules, and that we go through the right processes to get them modified, changed, or to have some discretion exercised in your favor where you want it to. And so that's kind of in a nutshell my presentation and overview of what some of the considerations need to be. There's one final thing I want to mention, which is this issue of giving notice to your neighbors, because we don't really have a strong culture of consultation in Jamaica. It very often happens that by the time that developers are consulting with neighbors, they have already gone to get their permits, and they've already hired their team, and they've already have the drawings in place, And at that point in time, consultation is really pointless. Because at that point in time, you're essentially coming to tell your neighbors what you are building, as opposed to get their feedback and input in it and make sure that it is not something which is going to create a problem within the neighborhood. So I would just indicate that, yes, the law has provisions in there which speak about giving notice to the neighbors, and unfortunately, those provisions are too often ignored, creating a very hostile environment while the building is going up and increasing the likelihood that somebody's going to try and take it to court, which will also add to the time of your development and increase the cost of your development. So it always makes sense to try and get your neighbors on board as soon as possible, as early as possible, and try to resolve any conflicts before you go and get your plans approved, because it'll be much more expensive afterwards to try to change something that probably wasn't done properly the first time. So again, thank you for having me here, and that's my presentation.
Well done, well done, well done. I definitely learned a lot. I do not envy what you and Shani do for a living. It's a lot of work, a lot of planning, a lot of research, and a lot of approvals. What I learned today was about restrictive covenants. I was never made aware of this, and it's very interesting that I come to these webinars and I keep learning new terms and new ideas. The restrictive covenants being, and again, I'm learning, so you can teach me along the way, being contractual agreements or arrangements between landowners. I understand that these covenants impose a restriction on the use of the land. Got that right?
Yeah. You got it right so far.
I'm learning something today.
Yeah, man. You're not going to get your F.
No, not at all. So I also looked at, we also looked at different types of law, like development and planning laws, what is permissible on the land. Some places can only be used for commercial and not necessarily residential areas, and vice versa. I learned about density, which is so interesting. And you touching on some of the challenges that developers are facing now when it comes to those laws, and a lot of them still being in review and not necessarily, actual laws as yet, and the challenges they face with that. When we talk about density, we looked at developers capitalizing on it and actually creating apartments. You touched on the fact that density is how many people are expected to live in a particular space. Did I get that one?
That's awesome. Right. Measured in terms of habitability.
Okay, awesome. We spoke about setbacks, how close you can be to a particular border or boundary, just to ensure for certain privacies. When it comes to like having a certain amount of space, building with enough space away from the border. And this can depend on the height of the building. We also speak about provisions when it comes to the amount of green space that's being allowed, the plans for sewage, the plans for the number of parking spaces, what is permitted in the different areas, and every area varies. Interesting enough, I also learned that there are certain things to keep in or to having as considerations. Things that I didn't even realize, like dust control, noise control, avoiding certain nuisances when it comes to persons in the environment when you are developing. Never thought about that. Very interesting. And each area has different restrictions, and these things can affect the permits that you have already received. I got that right, Mr. Goffe?
You got it right.
I'm ready to develop. On that note, I have some questions here from Gleaner Premium subscribers who are also as interested as I am to learning more. And I am opening the floor now for Q&As. So if you have a question, feel free to raise your hands so that we can acknowledge you. My first question from a Gleaner Premium subscriber says, Shani made mention of the steps, but it comes to mind that there are developments that have been halted, citing a breach of zoning laws or regulation. So how then do some developers start to develop before learning they are in breach, and how do they prevent that?
Shani?
Again, I'm drawing the short straw. Okay, fine. So remember, I said in my presentation that a developer should be patient. They should be diligent and responsible. Some developers are more adventurous than others. I'm trying to be nice about it. Some developers perhaps assess the risk associated with the permitted use, as Gavin referred to, the restrictive covenants, whatever that may be. And they probably have an optimistic outlook on when and how long and how involved that process might entail. There are other external challenges. For example, we must acknowledge that there are enforcement challenges. We have, we are generally speaking challenged with the resources that are in our public offices with regard to reviewing, processing applications, as well as monitoring developments when they're under construction. As you can imagine, Kingston and St. Andrew has numerous projects under construction and very limited staffing in the respective offices, for example, NRCA, NEPA, and the municipal corporation. And it can be challenging at times to keep track of those developers who try to undertake developments in a different order of things. So
Awesome.
I think that is my answer for the record.
Okay, I have another question here. And again, I am inviting those who are in attendance to send your questions over. If you're a little bit shy and don't want to be on the video, you don't want to speak, it's okay. You can send your questions via chat. We will definitely respond. Our next question from a Gleaner Premium subscriber states, in your presentation, Mr. Goffe, you largely mentioned high-rise buildings as a part of developments. What is it about Jamaica that makes a high-rise apartment more attractive than single-family and multifamily units in recent times?
Money, honey. That's really all it boils down to. You make a lot more money off of apartments than you would make off of a single-family residence. And that's where, the developers will follow where the money is. That's a short answer.
Okay, I know we have a question from Ruth Ann, who is from Proven. Nayoka, can you please read the question for me?
The question, Mr. Goffe made mention of studio size being a maximum of 500 square feet. Can you clarify, Mr. Goffe, the source for this information?
If you look in the 2017 Provisional Development Order for Kingston and St. Andrew and the Pedro Keys, you will see that it gives it there. And everything over 500 square feet, for each additional 100 feet, it's going to be reckoned as a 1-bedroom or 2-bedroom or 3-bedroom for habitable room purposes. And the reason for that is because people have been trying to beat the system. So they will go and get approval for a very large, what they call a super studio. And then after they've gotten the approval for it and it's been counted for density purposes as a studio, as in one habitable room, and they go and chop it up and put in drywall and convert it into a 1-bedroom or even a 2-bedroom unit, which then means that sometimes you're doubling or tripling the permitted density. So to be able to counter that loophole and that practice, they've started now to consider density based on the size of the unit as opposed to what you call it.
Okay, thank you so much, Mr. Goffe. Ruthann, I hope that answers your question. We have another question here from a Gleaner Premium subscriber. You have mentioned demolition of a property. What can lead to this drastic move?
If a development goes up without getting the appropriate permits, whether from KSAMC or from the NRCA, or if it got the permits, those permits are then quashed by the court, then that building will be subject or liable to be demolished, or is at risk of being demolished for a period, I think, of about 12 years from it when it's completed. So, I mean, some people believe, I mean, we're really yet to see any of these developments being demolished yet, but there are some orders have been made, let me put it that way. And we're still to see if they're going to be carried out.
All right, are there any other questions?
Sorry, I just want to add to my last answer. Also, for instance, if you build in breach of the restrictive covenant, right? If there is again, because the covenant is a contract between you as a landowner and probably your neighbor as a landowner as well. If you put up something in breach of a restrictive covenant, then your neighbors could apply to have your offending structure demolished as well.
So we just have one more, and it's from Rose. Nayoka, can you go ahead and ask the question?
Where can a purchaser verify the legality of property on the market? This is with the exception of NEPA, Real Estate Board, who appear to have, this one says, a teeth in enforcing these rules.
Different set of teeth, like that. I'll take a shot at that. But first of all, I think you need to have an attorney advising you whenever you're doing any kind of land purchase. Attorneys sometimes will be able to tell you officially or unofficially whether what they know about the particular developer. You know, as Shani said, not everybody has the same reputation in the market, and some people take greater risks than others. But essentially, the best person to advise you would be your attorney, and they can do due diligence checks that you may not even know need to be done or can be done.
Interesting. All right, so I'm seeing here clearly where the risk planning is coming in, where overall the planning is coming in, where getting all of the approvals is coming in. Yeah. This was, in fact, a very, very, very interesting conversation. I learned so much, and real estate has become something that I am just showing so much interest in. From the part 1 seminar to this seminar has been amazing, and I keep learning new things. So you never know, I might have to do a profession change after this. Mr. Goffe, I don't know if you're hiring. Shani, I'm certainly will want you over there.
We always need people to lick down things. So.
All right, we'll see how it goes. Thank you so much for being here. I know we have no further questions. We definitely had an amazing conversation. We have learned a lot. Thank you so much for watching. Please stay connected with the Gleaner Premium for part 3 of the real estate webinar series. Before we go though, I do want to ask both Shani and Gavin if you can share with me some information as to how persons can stay in contact with you if they need any further information or if they'll require your services in any way.
Sure. So you can find me at Proven REIT. You can check our website for the contact information, as well as I have a blog developed by Lovindeer that you can use as a reference tool for beginner, intermediate, and advanced investors, developers, persons who are thinking, as Talisa said, of a career in real estate. It's a field or an industry that has a lot of opportunities in various areas and sectors of the real estate industry. And there's tremendous value to be obtained in working in this space.
All right.
And for me, it is, I'm at Myers, Fletcher and Gordon, attorneys at law. We're downtown at 21 East Street. You can check out our website at myersfletcher.com, and our number is 922-5860.
Thank you so much again for watching. Stay connected with the Gleaner Premium for part 3 of our real estate webinar series. I am Talisa, and it was a pleasure.
Thank you, guys.
Bye. Bye, everyone.
Bye all.